SJC-12158, Commonwealth v. William Hebb.
Mr. DeMayo, good morning.
Good morning, Chief Justice Gantz. May it please the Court. Christopher DeMayo for William Hebb. The government's already tried Mr. Hebb for violating the OUI statute, Chapter 90, Section 24(1)(a)(1), based on an episode of motorcycle operation back on May 16, 2013. There was an acquittal. And the government is now seeking to try him again under that very same statute for the very same incident of motorcycle operation. And the question is, how can it do that without violating double jeopardy? And the government, as I understand their brief, has two different arguments why it's okay to go forward, so I want to try to deal with each of those. The first argument the government seems to make is that per se liability in the OUI statute and impaired ability liability are not only two different theories, which they acknowledge they're two different theories, but are in fact two different offenses or crimes. For instance, at page 10 of their brief, they say, the defendant's contention is based on the mistaken premise that the OUI statute, as amended in 2003, sets forth only one crime and only one way to prove the crime. Well, it does only set forth one crime. If you're convicted of OUI and the government has pressed both impaired ability and per se theories, you get one conviction, not two convictions.
How do you get around the homicide law?
Oh, well, the homicide law, I guess, what particular case did you have in mind, Justice Gaziano?
The three types of murder.
I don't think you, I think actually that this case, although at first it seems sort of like a curiosity, it seemed like a peculiar case dealing with OUI, actually has much broader implications because it seems to me whenever there are lots of statutory criminal counts where you have a single statute and it can be proved different ways.
So we have three theories of first-degree murder.
You have three theories of first-degree murder.
Jury comes back on premeditation. They say nothing about felony murder. They say nothing about atrocity, cruelty.
Well, that's fine. So they come back.
Right.
They come back with not guilty on premeditation.
They come back
Don't
with.
answer.
They come back with. They don't answer questions on two of the theories.
There's lots of law saying if the jury convicts on one theory and leaves the other two blank, the blanks do not count as acquittals. So that law still stands. I think, though, you'd have a problem. I think if the judge in a murder case did what Judge Locanto did here, and there was a disagreement halfway through, and he said, I'm going to take what you've got. Oh, you've only got premeditated, not guilty. The other two were blank because there was a mistrial. They disagreed. I think that's the end. I don't think you can retry them. And that's the same for larceny. Larceny, there's one statute, three different theories. There's like straight larceny, embezzlement, and
False pretense.
fraud or something like that.
False pretense.
False pretense larceny. In this case, this court, the closest I've ever seen this court come to these issues is they sort of touched upon them in the 2002 case of Mills, which dealt with somebody who'd been tried once under false pretenses, and then the issue is whether they could be tried again. If false pretenses failed as a matter of law, can they be tried again under embezzlement? And the appeals court said, no, you can't. They cite the Santa Bria case.
But in the murder situation, if you have three theories are argued to the jury, and special questions weren't asked, so it's a single verdict, guilty or not guilty of murder in the first degree. They answer it yes, and all three were argued. And on appeal, the appellate court says there really wasn't sufficient evidence for deliberate premeditation. So remand for new trial, but you can't argue, you can argue felony murder, you can argue extreme atrocity or cruelty, Commonwealth, but you cannot argue deliberate premeditation, and we have to have a new trial because we don't know which way the jury went,
I
right?
think, Justice Botsford, that's the same sort of idea as Justice Gaziano's hypothetical, which is you don't have an acquittal there. You have a finding of guilty on something, and you don't know what happened because you have blanks, or
It's the same, it's
it's
okay,
the same
I see.
thing. But if you have an acquittal, that's why I said I think there'd be a problem. If a judge in a murder case,
But you see, the judge in the murder case, at least if you had the three theories, I mean, and it's like what happens here. If the jury came back and said not guilty of deliberate premeditation and left the other two blank, but they had all been argued, it seems to me that the judge would need to send it back to the jury. That would not be the end of the case, right? Now here, the judge couldn't do that because you had the extraneous influence stuff coming in.
well, that's why I would suggest that in this kind of a case, the judge should not take a partial verdict. And I think that's already the law. I think I cite the 2002 case of Roth, where this court said the judge should never take less than a total verdict. And I think that would, on a going forward basis, solve this. Roth dealt with a judge who'd taken lesser included offenses. The jury had decided the large offense, for which the prosecution had charged, and they decided one or two of the lesser included offenses, but not all of them. And the judge decided, well, I'm going to try and take some of this stuff so we're not wasting our time here. And the court said, no, you don't do that. You take the entire count. There's only one count here. There's a count for 94-1A1. And the idea here, I think in the Commonwealth's brief is that you can divide it up, because when it says in 94-1A1, 0.08% blood alcohol or impaired ability, these are like separate elements.
But the judge divided it on the verdict slip, right?
He did divide it on the verdict slip. But they're not separate elements. Elements is sort of a term of art. It alludes to this court's Morey decision. In the Morey case, this court said a long time ago, back in the 1870s, a single act may be an offense against two statutes, and if each statute requires proof of an additional fact which the other does not, an acquittal or conviction under either does not exempt defendant from prosecution and punishment under the other. Different statutes. We're dealing not only with the same statute, Chapter 90, Section 24, but the same subsection 24.
The legislature do this? Why can't the legislature say, we don't want people on the road driving who are impaired by the consumption of alcohol? We don't want that to happen. And you know what else we don't want to have happen? We don't want to have happen people on the road who have a 0.08 or higher blood alcohol, and therefore we're creating two entirely different ways and two entirely different offenses to protect people who are on the roads.
Well, if they were entirely different offenses, Your Honor, it would follow that you could receive two convictions.
That's not always necessarily true, though.
I think for double jeopardy purposes, it is true, and we cite the
How about larceny and receiving stolen property?
Well, yes, and for the reasons I gave earlier, I think that if you would have the same exact situation here, if there was a special verdict slipped, he was found not guilty of one of those, of false pretenses, even though, and I would refer again to this court's Mills case, even though the legislature can certainly punish all kinds of larceny. If you take a partial verdict and one of them is an acquittal on that theory, that's the end of it, because it goes by the count. And this court, I know, just recently dealt with a case, Commonwealth versus Brandon Rodriguez, which came out last week, I think, and that was a double jeopardy case. In that case, this court said that just because a defendant has been acquitted of possession of stolen property, it doesn't violate double jeopardy to retry him for larceny of that very same property. But that case involved two statutes. 266 Section 30 is the larceny statute, and then there's a 266 Section 60 is the possession. So that case falls within Morey. This case does not fall within Morey. And I think there's a waiver. So that's sort of the argument. I think there's only one offense here. It's clear, and that's literally true. If you look at the complaint, there's one count. And there's no way really to characterize the two separate theories as offenses. They're all in the same subsection of 24-1A1. Now, the government...
Sorry, I'm just thinking out loud, but Sanabria, as I recall, you had this crime that factually there could be different ways of showing gaming or whatever was at issue, right? You could have numbers or whatever the other thing was, right?
Yes.
But the statute didn't mention you can prove by gaming or you can prove by numbers, right?
That's true.
Here, we've got a statute that mentions these two distinct ways of proving. And doesn't that make a difference?
Well, it's only one statute. I mean, that would be, the court would be expanding the Maury case to cover not only different statutes, but the very same subsection of 24-1A1. I don't know that it does make a difference. The idea in both cases is that there's one count in the complaint. There can only be one punishment.
But in Sanabria, they didn't separate out the horse racing from the numbers.
That's true, because it was a very general, statute that
Right,
applied.
so it was a general acquittal
Right.
under one count. Here, Judge Lecanto separated out the per se and the impaired theories.
He did do that, and he was sort of analogizing it to different elements of a statute, but it's all the same statute, I would argue, and it's the same idea as in Sanabria, which is if there's only one count and there's only one crime and there's only one possible punishment and there's lots of different ways to prove it, the government needs to bring all its theories at one time. It can't try them sequentially. And just because you can, in theory, break the complaint down into different theories or facts on a special verdict slip or when you're the prosecutor, it doesn't mean for double jeopardy purposes you can break it down, the single count. For double jeopardy purposes, it's a unitary count.
What would happen in a murder case if the three theories of murder, felony murder, premeditation, extreme atrocity, or cruelty, and after the Commonwealth rests, the judge allows the required finding on premeditation. And then while the jury's been out of the room, something happens and the judge has to declare a mistrial. Maybe a problem with the juror, whatever it might be. Does that mean that the defendant can't be retried on the two different theories of murder that we're going to go to the jury?
That's an interesting question. So the judge declares, directs an acquittal on one of the theories, and the other two are submitted.
Then
but
something happens that infects the jury, some extraneous information gets out, and does the judge come back in and say, I now find the defendant not guilty of extreme atrocity or cruelty and felony murder?
It may be better, actually. It's interesting because that's sort of what, in Sanabria, the judge actually directed an acquittal and then he sent it out to the jury. So I understand I'm trying to think of a way to argue around that. But if you take my theory that there's only one offense and that it can't be split up for purposes of double jeopardy, that could be problematic and maybe.
The difference between, I think, that example in your case is you actually had the jury acquitting on one theory. I mean,
You did have the jury acquitting, although Sanabria suggests that in Sanabria the judge directed the acquittal, and they did seem to suggest that for double jeopardy.
But the jury answered acquittal on the whole thing. I mean,
Right.
So what do you say would have happened if if there had not been the extraneous information before the jury, and the jury came back with a not guilty as to impaired ability and hung as to the .08?
yeah.
Well, when the jury came back, I guess what I'm suggesting is when the judge heard that they were hung, I'm sorry, okay, I see what you're saying. If they were hung as to the .08, well, I guess what I'm saying is the judge shouldn't have taken the partial verdict that they'd already reached not guilty on the first part. So it should be, if you look at Mass Rule of Criminal Procedure 27, this court's Roth decision, I take it to say, you shouldn't go into any of the details unless you have the entire count decided, which means every single theory subsumed within the count or every single lesser included offense subsumed within the count. So I think these issues wouldn't come up on a going forward basis if judges followed that, which seems to already be the law. It's a 2002 case. But to answer your question, I think that would be the end of that case.
Of course, the consequence of your proposed going forward practice would be that your client would be facing trial on both impaired ability and .08 going forward.
No, well, I'm suggesting my client's already been acquitted on the statute.
But if you had your way, there would be no partial verdict, and your client,
Fair
therefore,
enough.
the jury, so you'd be facing on both.
Fair enough. In future cases where this came up, the judge would say, well, they decided part of it, but it would be manifest necessity to declare a mistrial for the whole thing because I can't take just part of it, and you might escape being convicted because you're not guilty on this other.
Okay, thank you. Ms. Horan, good morning.
Good morning. May it please the court, Donna Marie Herron, Assistant District Attorney on behalf of the Commonwealth. I'm asking this court to deny the defendant's petition under 211.3, where the jury, although acquitted on the impaired operation, it does not bar retrial on the per se theory after the judge declared a mistrial with the defendant's consent on that. And I would say, as this court has alluded to, and as I've written in my brief, this is just akin to the murder, 3 theories of murder, where in Commonwealth v. Zanetti in this court, the defendant was tried under the old accessory liability under the joint venture, and the jury found him guilty as an accessory under the joint venture. And it came up on appeal, and this court said there's insufficient evidence that, and it directed a verdict for him as the accessory, but remanded the case back for retrial as the principal on it, and said double jeopardy and didn't bar retrial on that. And I would suggest this is exactly the same case here, where the jury came back partially on impaired, and indeed the Commonwealth could not go back and try the defendant on the impaired theory, but
So your theory is these are separate crimes?
separate, that merge if there is a conviction, then obviously it merges because you can't be,
Is it permissible for the Commonwealth to charge someone with the impaired theory and not the per se?
yes, you can charge only one, and then you'd have to get the retrograde extrapolation as undeclaratory.
All right, so the person's found not guilty of impaired.
Yes.
Can you then bring out a second prosecution and try them for the per se?
I think you could attempt to, yes, but
Well, haven't you just already tried the person for the same
yes,
criminal offense?
then I don't think the Commonwealth would do that, no. I don't think you could.
Other than would.
No,
Can
because exactly like, no, we couldn't, because like under the murder, if we tried murder only under deliberate premeditation, we would be barred from retrying it under the different theory. So just like that, you're right, we would not be able to retry on the per se violation. But here, where the complaint listed both impaired and per se, the jury was instructed that they had to find unanimous as to each count separately, and the verdict slips were separate. They were separate, one for impaired and one for per se. I would suggest that it doesn't bar retrial under solely the per se theory.
Is that the way it's always done with 2 separate counts?
Traditionally, the way the indictment reads is OUI per se, and then
You're treating
impaired.
them as separate crimes?
We do in the district court, and then obviously it merges if the jury comes back guilty on both. Although there's no law that says it, we merge them into one sentence.
The jury comes back with guilty on one,
Then
then what?
you sentence on that one. That's traditionally how the district court does
It's the
it.
same sentence that you'd be given if you had it guilty on both?
Yes,
Correct.
correct.
Because it's the same crime.
Yes,
And in fact, in your complaint language, that's the way the computer spits it out, and you had to cross it out, right?
yes, you would, back in. So, I mean, that is the way, and just like murder, there's one murder indictment, but there's the 3 different, and then the jury's instructed they have to unanimously find on the 3 different theories, on the extreme atrocity, deliberate premeditation, and the felony murder. It's just the same as that, and that if you get conviction on one, then you get the life without parole.
If you, I'm not sure of this, but if you were charged with larceny and receiving stolen property, same property we're talking about,
Yes,
they both can go to the jury, right?
yes,
But you get one sentence?
you do.
Okay.
And as this court recently said in Rodriguez, in a similar situation where they were not guilty or the judge directed out on the receiving, I believe this court said we could retry on the larceny. And then on that point too, I'd like to point out the mills that the defendant has referenced. And in that
Mills?
case,
Yeah.
this court actually, this took it up on FAR, and this court found there was insufficient evidence of the larceny, which the jury convicted the defendant on, but remanded it for larceny by false pretenses. So I actually think it helps the Commonwealth and not the defendant in that case. So I just want to note that that's what this court did in Mills. Remanded the case back for the counts of larceny by false pretenses, even though the jury came back solely on larceny charges.
Would the, just to avoid the issue, could the judge at the time have just not taken the verdict, kept it, and then
Yes,
dealt with the .08? I mean, in other words, retry the .08. I don't know.
It's hard because then you would have the defendant come in.
Oh, you have to have a whole new jury. That's right.
Yes,
Yeah, right.
but
Yeah. Okay.
So I guess maybe the defendant's argument might be, case goes to the jury on assault and battery intentional and assault and battery reckless. And you have a not guilty on intentional. The reckless, they don't reach. You couldn't retry that.
well, again, I would suggest if they have two verdicts slipped, the Commonwealth would ask the judge to inquire as to their verdict on the intent of it, whichever one you said was a flink,
Right.
whether they found reckless, and then it would be resolved then, because you'd be asking the jury, what is your verdict on the reckless? It's just here, we weren't able to go to that last step to ask the jury, what's your verdict on the per se, because of the unfortunate influence that they saw that it was his fourth offense. I don't think the Commonwealth should be barred in a double jeopardy principles from retrying on the per se count.
And what is your view as to whether a partial verdict should be taken?
Well, since we're here, I'd suggest probably shouldn't take a partial verdict.
So what should the judge have done?
Probably declared the mistrial and said.
Whole thing,
On the
and
whole
then
thing.
start all over
And
again.
asked why couldn't they come, what was the thing they saw, and they would have said, we saw that it was his fourth offense, and then declared a mistrial over the whole thing and redone it all at once.
Yeah.
Although if the jury had found him guilty of impaired ability, and the judge had found that that was not tainted, we probably would not be here.
I
No,
assume
but I
that's
don't
why
see how the judge could find that's not tainted when they knew it was his, how could it taint on the per se but not the impaired when
Okay,
they
I don't know
knew?
what the facts are.
Now,
but
what
the
the
judge
judge found
found
here?
that the judge found that it was not tainted, I guess.
Because it was not guilty.
No, but he
There's a
hadn't
fourth-
taken it at the time, I thought. I thought he didn't take it until
Asked-
afterwards.
He said I believe the record shows they came back and said they had a problem because they saw something it shouldn't have said. And then the judge said, does it affect both? Because he views it as two counts. It affects
Well,
both counts.
they came back on they said that we have a verdict on
One.
impaired, but we have a problem.
Yes, you're correct. And then he asked what the problem was, and then he asked if that impaired their verdict as to the impaired. It's a unique set of circumstances.
Then they
I'm
found out it was
assuming
a
that they
fourth.
hadn't seen it by the time they reached their verdict on the impaired.
Oh, no, they'd seen it, but they came back to a not guilty, so I guess that's why they said it didn't impair their ability to, or influence their verdict on that one. Which, in a way, in this case, the factual case kind of, in a way, makes sense since it was a motor vehicle accident, which wasn't the defendant's fault. But then he was taken to the hospital where they drew his blood for medical purposes, and it came back a .133. So in a way, you can kind of see what the jury was thinking then, but I don't want to speculate as to that. But I just would say under the double jeopardy principles, I think the Commonwealth should be able to retry the defendant under the per se violation only. And I'd ask this court to deny the defendant's petition.
Okay, thank you.
Thank you very much.